Law. Thanks so much for tuning in to our program today. I decided to even start a minute early for all the times that I start late. So, in today's Ask a Lawyer, I'm interested in the questions that folks put out there, um, and certainly appreciate everybody attending to this and watching this show, getting information about this. Remember that in these days of COVID, it's harder for people to get legal advice and get legal information. Um, uh, so that's why we do this show. That's why we do this Ask a Lawyer show. Um, I'm going to put up my own question here to start us out. So, what kind of Gary asks, what kind of Gary Berger asks, what kind of legal cases or cutting edge stuff are you working on? Great question, Gary. I love the question. Here's an interesting issue. We had a case where the Missouri Supreme Court just handed down a case on co-employee immunity under workers' compensation law, and we represented the family of a young man, and that affects our case. We represented the family of a young man who was injured because of the negligence of his co-employees. He was in the back of a trailer surrounded by new trash cans that were being delivered, being rolled out in St. Louis County. And the driver took a turn around the corner. The trash cans, which were filled with water, were not strapped down as they should have been. They all were heavy and filled with water. They hit him. They threw him off the back of the trailer, and he sustained a head injury and died. So we believe that the co-employee negligence of the bosses for failure to make sure that the load was tied down, as well as the driver for taking that turn too fast and throwing him out and killing him, was a civil claim that we could make. Otherwise, his claim was limited by workers' compensation because he was working at the time of the incident. Even more challenging was under work comp. He was a young man, he had a sister that he supported. His parents had predeceased him, sadly. He lived with grandma. So there was only a limited amount of money we could get for him in comp for his sister, because comp laws provide for the wife, provide for the kids of a deceased worker or the husband of a deceased worker, but do not provide good benefits to this situation that we were faced with. So we went and we lost the case on summary judgment. We took the case to the Court of Appeals, to the Missouri Court of Appeals, and argued that case about uh, 2 years ago. And at the end of the oral argument, I orally argued it. We did it at Fort Zumwalt North School. So it was in an auditorium where the kids in high school got to watch a Court of Appeals argument. It was a pretty cool venue and a pretty good thing. It was really fun to do in front of a bunch of high school kids. I love the Court of Appeals does that. And then then at the end of the argument, the court said, we're going to take that under submission. And we're not going to submit the case. Actually, one of the judges asked me, should we submit the case or should we wait for the Missouri Supreme Court's ruling? And I said, wait for the Missouri Supreme Court's ruling. Go ahead, because that's going to impact this. And so that's what they did. And then the Supreme Court just recently, 2 weeks ago, entered a ruling that went against us. So this young man, his sister and family will have no remedy for his death other than comp, and the comp claim was very low in the comp claim. So it's a very sad result, and it's a real movement. There was even a case 2 years ago. There's some real movement of the court on this to prohibit, constrain, prevent any claims against co-employees if a injury or death arises out of a workplace accident. So the question is, am I limited to workers' compensation recovery if I am injured or my loved one is killed in a workplace injury? an accident? The answer is yes. You can have no claim against co-employees or bosses or anybody else, even though before work comp you were entitled to have those claims. So that's a pulling, that's an elimination of a category of claims that people used to make and people arguably could make. And so that's one of the cutting edge cases that we did. We do all kinds of other cutting edge litigation in our firm, in our law firm. We do class action work in a variety of circumstances. It's cutting edge. We progress injury claims and theories and products liability claims this summer. The case we resolved this summer that are cutting edge, pushing the envelope. We're always trying to make sure that people's rights when they're injured or otherwise aggrieved or ripped off don't retract, that we at least maintain the line of the types of claims and remedies that people have. That's one way we were seeking to do it. The Missouri Supreme Court went against us in that way. So there you go. Let me turn to other. We have other questions that are loading up our chat on this, and let me take some of them. Eric asks me, what are the most common and most difficult hurdles in medical malpractice or birth injury cases? Thanks, Eric. Well, so to maintain a birth injury or a medical malpractice case, first thing you need to do is make sure that there is breach of the standard of care. I mean, if the doctors or nurses who provided the care breached a standard breach or were negligent in providing care. There are standards in birth injury cases for monitoring heart strips, making sure that the child is not having decelerations in their heartbeats, make sure there's no fetal distress in a child, in an in utero child, making sure that there's no hypoxic, ischemic, or encephalopathy type of injury to the child. And then that's why doctors do cesarean sections, is that if there is a lack of oxygen in the baby during that birth time, it's a dangerous time for children and moms, as we know. But for children, they can have an oxygen insult deprivation of oxygen to them that can cause brain injury to children at that time, and that's what typical birth injury is. Another type of birth injury often is a brachial plexus injury, where doctor is not maneuvering the shoulder in a birth that can go up against a pubic bone typically and can get caught, and then the shoulder gets caught, the doctor yanks too hard, and the nerves are ripped out from the child's spinal column, and that's called a brachial plexus or an Erb's palsy injury. Those are the two most common birth injuries that we typically see. There could be others. We see others. And then in medical malpractice cases, that can run the gamut of other types of medical malpractice cases. But the challenge is, number one, there's four main challenges. Number one is making sure that there's medical negligence and medical error, a standard of care that was developed and it is the standard of care that everybody should get, and the doctor or the nurse or the medical provider do not provide it. Sometimes at nursing homes, it's medical aides and not actually nurses who are providing the care. Number two is you then, once you vet that, when you make sure that that is true, you hire a doctor to give you or a nurse to give you a written opinion. It has to be in the same specialty. The nurse you hire, the doctor you hire has to be in the same specialty as the doctor you're going against. And then you need to have them review all the records and have them write an opinion letter, it's called a letter of merit, or a letter saying that there was medical malpractice and that malpractice caused or contributed to cause the injury of the person. That gets to our third point, and that is that to be able to win a medical malpractice case, you have to prove that the negligence caused or contributed to cause the injury or death in a person. And many times that's where these cases are aggressively defended. They are defended on the standard of care, but sometimes the standard of care, that we know that the doctor really did follow the standard of care. The question is to make sure that that error caused the injury of the person. Let me give you an example. If you break your arm and you go to the emergency room, they don't diagnose you. Then that day you go to the emergency room the next day, they diagnose you with a broken arm, they put you in a cast. Although the first hospital should have diagnosed you with that broken arm on x-ray, they didn't. However, so that's malpractice, arguably, right? However, there's no causation of damage because the next day you went, got it diagnosed, and then you followed in your treatment and you were treated for the broken arm. So there was no that negligence on the first day going to the ER did not cause you injury or damage because you were able to do it the next day. And then fourth is there's limitations on damages. The other challenge in medical malpractice cases, there's limitations on damages that you can get. In Missouri, we have caps on damages. In Illinois, there's other constraints on damages. It's not as stringent as Missouri or even near, but there's other things. So there are limitations on damages of non-economic damages or damages you can prove from a causation point of view. So those are the most challenges in Eric in the hurdles and those things. Brennan asked, should I go to my boss or to a lawyer if I'm injured on the job? First, you go to your boss. You file a report of injury. You tell your boss, I was injured on the job, Brennan, because you don't know when you're injured on the job whether the how bad the injury is, right? You don't know that. So sometimes you may have a bump or a bruise and you're good the next day. Sometimes you have a bump and a bruise and you have that broken arm that you had to go to the ER for twice in my last example. Or sometimes you hurt your neck or your back and you don't know whether that's going to be a herniated disc, it's going to cause lifelong problems and need surgery, or if you just tweaked your back or your neck, you're going to be fine in a couple of days. You don't know that. So report it to your boss. Tell your boss the date, the time that it was taken, the date and the time that you were injured, how you were injured, what part of your body you were injured. And under those circumstances, your employer is likely to send you to Concentra or to one of their providers. Go to their provider, get the medical that they're providing, go to that provider and get that care. And then see how they're treating you. If you have a significant injury requiring surgery, requiring major problems, major disability, call us, we can help, we can add value to the claim. We don't charge on medical expenses. We don't charge on temporary total disability. We charge 25% of the lump sum disability payment that comes at the end of a case. So that's how you should handle that. Thank you, Brennan, for the question. Let me go to the top now and get some other thing. Have I ever lost a case? Thank you, Kaylin. Yeah, I have lost cases. I've lost a handful of them or less in all my trials over the years, and those stick with you. If you ever, everybody knows, or you can Google that old Teddy Roosevelt quote about being in the arena and getting your face bloodied. And as a trial lawyer, me and the other team, my other lawyers that work with me, that I'm lucky to have working with me, we push the envelope in cases. I just mentioned that case at the beginning of this session where we lost a case. We didn't try it, but we lost it in the Court of Appeals on a motion to dismiss because the court said you're not allowed to have that theory. I've also tried cases that I remember every single one for the best clients, the best people, where we have put it all on the line and we put our heart and soul in these cases, and then the jury may come back and not agree with us or not agree with the level of damages that we would consider a victory, or not give us what we believe is full compensation for our clients. And I didn't set this up, but I am drinking out of our cup, which I have the definition of compensate. I've always put on the back of our cup for a while. And that's what we try to get for our clients, and it keeps us focused on that. So I have lost cases, and they're hard because you get to know the clients and or their families so well, and you really feel for that and really feel for their lack of recovery, because you end up knowing their injury so profoundly because you helped them navigate the care. You've gotten the late night calls and the texts. You were in the depositions. You're prepping them. You know the pain and how real it is. And it's not that juries ignore that, but for some reason, for sometimes the cases, a jury may not agree with you. May not agree that a doctor was negligent. They may not agree that a corporation had a defective or dangerous product, and that you have not sustained or sufficiently sustained that burden to prove that. So those are the circumstances mostly in which I've lost cases. But we're happy to, but those clients, to every single one, are so often so appreciative and have so much gratitude that they got to fight the fight, that they stood up for themselves, that they did progress that claim, that they did fight that fight, which is fantastic for clients to have that gratitude and have that sincere appreciation for the work that we've done for them. And you know what? That's also, one of the things about our firm that we have a reputation for is fighting the fight and going to trial and doing these things. So we believe and think that that adds value to the cases of our other clients, because the other side knows that we're going to take the hard case, we're going to fight the hard fight, and we enjoy doing that. Let me move on to a question from Maya. Maya asks, what makes someone a good client? What behaviors or qualities make someone difficult to work for? Oh, maybe I shouldn't take this question. No, I don't mind doing it. So what makes a good client? Well, you know, uh, clients come, and I've represented thousands of people over the years. People come, and just like it is in life, right? People come in all shapes and sizes and attitudes and expectations, whatnot. What makes a good client? I would say, well, we're not going to. First of all, they're not going to be our client if they didn't have a real tangible injury because of another person or company's real tangible bad action, rule breaking, or negligence. So let's assume we got the and that's liability, right? Liability that someone else caused and caused an injury in them. Then what makes a good client is someone who's coachable, who's someone who is open to hearing our advice. We will give advice to a client over the tenure of the case. And that comes from me directly, comes from lawyers that work with me directly, paralegals. We also have a system and program of many, many emails and videos that go to clients to teach them about things like, hey, this is going to be the limits of insurance in the case. This is in a car crash case. This, if you have underinsurance, what other insurance is available? Get all your medical care. Teach you about medical care. Teach you about product defects or the medical negligence issue. Depends on the type of case. You'll learn how challenging these cases. What are the challenges in the case? What are the hurdles in the case? What are the things that we need to get over or get by to either resolve the case or win the case at trial? And so you want to make sure that the client is open to learning about that, and you want a client who is going to understand and get that they're ultimately at the end of the case going to make a decision on whether to settle the case or try it. And we want them to be an informed consumer and a savvy person, even though this is not their area and they've never done it. And that is every single one of our clients. Every single one of our clients comes to me and says, listen, I never thought I'd have to be here hiring a lawyer. Or, hey, listen, this is the last place I think I'd be. Not only did I get hurt, not only did I get injured and have medical expenses and not be able to work for 6 weeks now, and then I have to talk to this insurance company, and they're a bunch of jerks to me. So now I got to come and hire some random lawyer that I don't know, that I see these videos for. What's the deal? I don't want to do that. But sorry, but I kicked my computer. So no one knows about this system. So people need to learn about insurance and policy limit demands and bad faith and medical care and what liens are in the case. Who wants their money back out of the case? Who are the defendants? Who are the target defendants? How much insurance they have? What are our theories against them? Are they going to fly? What's the time period to file a suit? Let's get our demand together. How are we going to prove wage loss damages? How are we going to prove liability? What investigation do we need to do? What experts do we need to hire? How are the expenses in the case going to affect me? Does your firm have the wherewithal and the resources to pursue a case? What are the odds of me getting more money if I don't settle now? There's a tension between quick settlement and good settlement sometimes. These insurance companies and corporations and folks, they don't want to pay out easy. We have to fight them for it, sometimes for a while, before they realize and appreciate the wisdom of our position. And then they're ready to pay what is full compensation. What is full compensation for a person's injury? But sometimes it goes slow. I can't tell you how many times we get that offer, we get that good offer right before trial. We're always taking video depositions for trial and doctor depositions and that kind of stuff. I think there's a deposition going on at Tyler's office right now, or there was today. The second part of Maya's question is what behaviors or qualities make someone difficult to work for? Kind of being one of the behaviors or qualities is when no one wants to work with a jerk. So, you don't want to work with someone who doesn't have gratitude for what you're doing or wants to take their frustration out on you or their staff sometimes. And also, I don't like when people are like mean to the paralegals and the receptions, the other people, when you're on the phone, they're like all nice to you and stuff. I'm like, well, that's weird. I want you to be nice to everybody. So if we get someone who is going to treat us like that over a long period of time, then that's harder. That's a harder person to represent. Now, let me say that sometimes people are in a tough spot when they get hurt, and they're hurt physically. And so sometimes that frustration, those emotions, that life interrupted, that economic hit that they're taking, which is significant and real, that can come out crooked. And they can be frustrated with me, frustrated with the process. That can happen. I'm good with that. I can handle that. Because what happens with those people is you explain it to them and they're like, oh yeah. And I say, listen, this defendant's saying this, but it's not fair that the light was red for him. It wasn't green. I know, but they're lying. So this is what's going to happen. And we're going to get around it. It's going to take time. We're going to get around it. We're going to be able to get a success here, but we got to deal with that. It's nothing that I created, nothing that you did wrong, client. It's something from the other side that we got to get around. That's just kind of the deal. And unfortunately, the civil justice system that we have, that we practice in, that we get recoveries for in personal injury cases is great. It's the best system in the world, but it's also the best worst system in the world because the defendant gets due process too. They get to come and put in all their arguments. If you think their arguments are bogus, well, that's your deal. I know I've said I've lost a few cases and that happens. So sometimes justice can seem crooked. Justice delayed is justice denied. That is true. And so there you go. I know I kind of rambled a little bit, but those are my thoughts on that question. Let me go to the next question. So Brennan asked me, I asked about door cams last time. What about the usual traffic cams that seem to somewhat disappeared live on intersections? Great question, Brennan. The reason why those disappeared, I think, is because those red light cameras, the court said you can't keep doing that because you don't know who was in the car that blew the red light. It could have been not Gary Berger's car. It could have been my wife in the car, one of my kids, most likely, right? So that's why they're disappearing. I've tried to get those in cases, and sometimes I have to show lights, but those usually cycle over and right over each other pretty quickly. Those are hard to get. I do get security cameras. I have a number of cases where I've got security cameras footage from adjacent places. Right now, I played one in a deposition and showed this guy. I'm like, here's the video. Are you crazy? That did not happen like you said. And I couldn't move him. Whatever. But whatever, we got the video for it. So those can help. I've tried cases with cameras. I tried a case with a camera on a bus one time that showed my clients riding her bike into the side of the bus. So that was it. I mean, it showed that the bus turned in front of the bike rider, but it also showed my client like throwing her hands up, yelling at the bus, "You turned in front of me," instead of just hard braking. Again, she was reacting as well as she could at the time, but cameras can go both ways. The video stuff can go both ways. So I'm going down my list of questions. Here's a question from Kaylin. Well, you know what? I'll do that question from Kaylin. Kaylin asked me, what advice can you give to someone who has just suffered an injury and is trying to find out if they can make a claim? Great question. First thing you do is make sure you get your medical care and take care of yourself physically and health-wise. Secondly, make sure that you can gather any evidence you can to support your claim. If you're in a car wreck, take a picture of your car, of their car, of the person who rear-ended you, their driver's license, skid marks on the road. Take a little video. If lights are cycling and you went through an intersection, and they're gonna say later that that they had a green arrow, show that they could not have had a green arrow. When you went through the green light, they had a caution, they had a yield light. Um, I've had many cases with many great pictures at the scene. If your car gets entangled and gets underneath a semi because a semi came into your lane, and take that picture after you're out of the car. Show how bad that was. Show how scary it is to be sucked under or be hit by a 70,000-pound tractor trailer. Um, the story that is told, if you're in Walmart or if you're at a store and there's wet floor, take a picture of that because it'll show that there's no wet floor sign, and then you'll have evidence of that. Everybody's got their phones. Um, take a picture of a medical record. You don't know if I'm saying you secretly record audio on people. I don't know if that, most of the time that backfires. Most of the time that's not worth it. But these pictures that people take at the scenes, whether it's a slip and fall or car wreck or something in medical record or something, like, because you don't want that to disappear later. That can be really good. Or we also have fall cases in medical context or nursing home cases. Your mom has a decubitus ulcer. Your mom has frequent, urination, and they won't clean her or whatnot. That's not good. You could take pictures of that, document that. A picture's worth 1,000 words. And then what the person who's just injured is going to run up. So get the evidence, take care of your health, get the evidence you need. Third is, if you're talking to the defendant about resolving the case, whether that's the insurance company in a car or truck case or motorcycle case, whether it's the store owner or Walmart's case manager or their claim representative or the insurance company for whoever, or if you're talking to doctors or people, don't succumb, or don't you want to listen to them, but do it through the filter, do it through your bullshit filter of making sure that they're not lying to you. So we run into this all the time where claim representatives will tell people you can't recover, you can only recover for 6 weeks of chiropractor or PT after an accident. You cannot get wage loss damages because you got paid for more. These are all things that are untrue. They're false. They're telling you that this to get you to settle low. Oh, you know what? A lawyer's just going to take a bunch of money from you and you're not going to add value. That's not true. We don't take a case unless we're adding value to it. Oh, you know what? You were partially at fault. So we're going to discount this by 50% because you should have been looking at the floor and seeing the clear liquid that you couldn't see when they have all their signs and you're showing, hey, buy me this, buy me this. And they didn't monitor the water coming out from the ice machine that they've known for years has been there, or you were going through a green light and someone turned in and hit you in the side and they say you should have yielded. No, they should have yielded. Or they will say, there's only so much of insurance here. You can only recover this much. You can only get med pay. We're not going to pay you anything more. Well, you know what? We've had a million cases like that, and they do pay us more because they should be paying you all the compensation to which you are entitled, not 50%. So, or you need to do this quick, or, I can only pay you your medical plus $1,000. That's all you're ever going to get. Well, that's not true. This is not true. They're going to tell you all kinds of things, and they're going to hound you. I can get you a check tomorrow. When do you need it? Da, 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 da. Don't do that. You need to get fully compensated. This is the only chance you'll ever have to recover in this case is this injury case. And look, if you only go to one ER visit, you're not that injured. I cannot add value to that case. So you can go ahead and settle. But if you're seriously injured, have more than a couple doctor's visits, and you have an injury, a lawyer like me can add value to your case. So then the next step is the last thing, and I know it's just call a lawyer. Is this question is set up for call a lawyer? Just call me? No. But then you call a lawyer. We'll answer your question for free. We'll tell you whether or not we can add value to your case, whether or not it's worth it for you to hire us or not. There's a lot of lawyers out there with a lot of information, and we do too. But lawyers, me and a lot of other lawyers, we'll answer your question for free. Burger Law will answer your question for free. And we can tell you whether or not we can help you. Let me go to a new question. Is there a difference between negligence and strict liability? Yes, there is. There is a difference between negligence and strict liability. The difference is that In a products liability case, there was a case years and years and years ago that invented products liability by a guy named Learned Hand. What a great name for a judge. His first name was Learned, Learned, Hand. Anyway, if a manufacturer has a duty to put products in the stream of commerce that are not defective or dangerous when put to the reasonably anticipated use. That is what products liability law is. So if you have a product that is dangerous or defective and that cause an injury to a person, that is strict liability. The product manufacturer, the person who made, designed, manufactured, and distributed that product is automatically liable for the damages that defective or dangerous product caused. Now, that can sometimes be different people. Somebody may have designed it, somebody may have made it, somebody may have distributed it. If that's the case, all three are strictly liable. Although most states have a statute that says if all you did is distribute it and the manufacturer's in the case and is solvent, it can pay the judgment, the distributor can get out. Missouri and Illinois have that statute, and many states do. So that's what strict liability is. Negligence is you have to, it adds another layer in that proof. You can have strict products liability. You can also have negligent products liability. Negligence products liability isn't strict. That's the difference. What negligence says adds another requirement that says that the manufacturer, the distributor, something had to be negligent in that design. So there are some products that are dangerous, but they were not negligently done. For instance, there's a lot of construction equipment, jackhammers, bulldozer stuff. If a bulldozer comes down on your foot, then and maybe this is a bad example, but that is, did it hurt you? Yes, but that's not negligence for the product manufacturer. So product manufacturer, then a negligence is a different standard for products liability. Usually when we plead, and there can be different jury instructions for negligence or strict liability. In strict liability, comparative fault may not apply. In negligence, it's comparative fault because if someone's using the product badly. Negligence also brings into account a failure to warn. So there are some products that have inherently dangerous natures to them, like a bulldozer, like a pool, like a trampoline. But if a manufacturer warns of those dangers, then they can get out of liability, saying, we warned you guys that. You guys know when you're driving a car, you can't, it goes 80 miles an hour. That can be dangerous. You got to be careful. So we're going to have warnings about that. You can't look at your phone while you're driving, that kind of stuff. So now the question is whether that warning was adequate and whether it was non-negligent. If it wasn't negligent, if the warning was good, plastered, that red diamond that says warning, don't do this, clear, communicated, then that might not be negligent. But if a manufacturer doesn't do that or does a bad warning or it peels off easy or it's not in yellow, blah, 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 then that might be negligent. So that's generally the difference between negligent and strict products liability. Let's go to one of my captions. Visit us on the web at burgerlaw.com. We answer a lot of questions in our FAQ or frequently asked questions section of our website. We have a lot of videos on our YouTube channel that answers questions. We try to do this in a multiple of contexts. I got a lot of questions coming up. Let me see. I got a lot of them. Let me go to someone who I haven't gotten a question from. I have a question from Jeff Gutshaw. Jeff asks, can you explain the UIM process, underinsured motorist process in personal injury accident case, and specifically why there is a need to notify the UIM policy when the at-fault coverage? Jeff, are you the guy that I talked to? I hope you are. I talked to you earlier this week, and I was talking to you about that. You have a lot of good questions. And the need, why there is a need to notify the UIM policy when the at-fault coverage makes a policy limit settlement offer. Additionally, does the UIM have the ability to say no and so why would that happen? So let me answer that question. So the UIM process in a case is that oh, sorry, I'm getting text from my daughter. Lord, the you notify the UIM holder because they could tell you, listen, I know that this driver has only $25,000 in coverage. And I know that you have $100,000 in UIM. And I know that you want to take the 25 from that driver and give them a full release so that no one can ever sue them again and then come after us for the 100. But we looked, and this driver lives in a $20 million house and has $20 million in the bank. So we don't want you to settle your case for 25 grand. I don't know why the hell he had terrible insurance, but this guy's got money. We're going to go after him. So instead of you settling with that tortfeasor, instead assign us your claim or go with us in your claim. Don't do that yet. Let's try to get a better recovery against that guy because we'll never be able to go against that guy. Or that guy owns 5 houses or whatever the deal is. They want to make sure, and they also want to make sure that you're not doing any kind of, I think probably any kind of scam, like you get hit by a friend of yours or something. Because it's a contract, and you have to notify them. They have to know about it. They also want to make sure that that you didn't miss any insurance. What if the other side has they give you a $25,000 offer, but they have excess or umbrella insurance that you never asked for. You never asked for an affidavit saying that that's all the insurance they have. They want to make sure that, now we don't have that with our office, but all kinds of folks come to their insurance companies with UIM or underinsured motorist coverage. They want to make sure the person is really underinsured. And so there you go. Do they have the ability to say no? No. You can settle your case with them. They don't have the ability to say no. They have the ability to say, this is how this is going to affect your UIM claim, because we want to vet this guy and make sure this lady, make sure she's not a multimillionaire. But did you leave med pay on the table? What's the med pay? There's other stuff. So there's other stuff about that. Jeff, I hope I answered your question. You can always call us if you have more questions. So Genevieve asks, if an employee has a workers' compensation claim, Genevieve always gives me the hard ones. If an employee is going to have a workers' compensation claim and the doctor puts him on permanent restrictions, no lifting over 20 pounds, but his job requires lifting over 20 pounds and can't accommodate, can his employer fire him for not being able to do the job? No, you have protection from being fired. You can't retaliate for making a workers' compensation claim, and you also can't violate the ADA, the American with Disabilities Act. You typically, if it's a permanent restriction. Now, let me say that if an employer does not have any work that would comply with a permanent 20-pound lifting restriction, they do not have to further employ that person. So let me qualify my answer by maybe. And you can't do light duty forever, as she asks. You're not firing. You're separating him from his employment because the doctor has restricted him out of doing the job. So you got to be careful in a work comp case that you don't get restricted into that. So thanks for the question, Genevieve. And DJ Bucci asks, Do radiofrequency ablations have value? The answer is yes. The question, it's a little confusing question, and it's okay, it's well asked, whether it has value. They have value, they add value to your injury case. They also have value because some people that will decrease their pain or nerves. So that's a radio frequency ablation that decreases the irritation in the nerve when a nerve root is being impinged upon, typically with a bulging disc or a herniated disc in the neck or the back. Or there can also be general swelling in that area. There's other ways, other phenomena when those injuries occur that can irritate the nerve root, causing pain, referred pain, numbness, and a lack of musculature, muscle development, lack of innervation to the part of the body that's affected. They do have value. And the other thing is that like 20 years ago, most doctors would just throw a lot of opioids at those type of permanent conditions. We don't want to do that anymore because doctors and physicians in our society appreciate the addictive power of these opioid medications. So long-term opioid dependence and opioid use is not a solution anymore. So I think radiofrequency ablations are being used and used more. They have to be done by a good person. They got to get the right area. Sometimes the ablation will also tell us what area is affected. They may ablate one area, doesn't work. They go and ablate a different area. Lo and behold, it helps the pain. So it is a good non-invasive, non-surgery, and non-opioid medication drug option for folks. So let me turn to Jennifer's question. Do you have to have car insurance to make a claim if you're a passenger in a vehicle? No, you do not. And so it doesn't matter what state you're in, if you're a passenger in a vehicle and another person broke the rules of the road and negligently injured you, you have a claim against that driver. Now, I will say that the claim that you have is against the driver. Let's see, it could be a driver in another car. You may have a claim against the driver at the car that you were in. So if you were in a car with your friend and they blew the red light, you have a claim against the driver of your car. Don't be afraid to make that claim. Some people say, oh, it's my buddy, I don't want to make that claim. Listen, that's why your buddy has car insurance. So I would definitely do that. Make that claim. Jennifer can also be suggesting there has been tort reform in Missouri only that says that if you don't have insurance and you're driving a car, that you're limited in your recovery to only your medical expenses. You cannot get damages for pain and suffering, and that's what that law says. So that could also be referenced in that, but that does not apply to passengers. Rodney asked me, Rodney McBride, thank you, Rodney. What do I have to prove to win my defective product liability lawsuit? You have to prove that a product was defective and dangerous when it was put in the stream of commerce, when it was made and distributed, and that defect proximately caused your injury. To prove product defects, we often hire engineers in our firm. So you'll hire a mechanical engineer or a chemical, some type of engineer, some design person in that area. Usually we'll have articles, we'll have old engineering articles. There's also different reporting requirements for defective cars or defective medical products or defective stuff. So you need to prove that to win. You need to prove a defective condition in that there's all kinds of classic examples of defective or dangerous products. We take these cases, we're litigating a bunch of them now. You also have to be able to get around the defenses, okay? So especially with federal regulation, some of the strong, pervasive regulation in certain industries, there's a lot of defenses the defendant put up. Like their claim was preempted because the federal government came in and regulated drugs, medical devices, or cars. Or they'll come in and say, hey, this was the state of the art, the best it could ever be designed. You can't design this thing any better than this. Or it is complied with regulations, or this wasn't defective or dangerous. They'll put that in every in every case or assert that defense in every case. So you want to be able to get around those. So not only do you have to prove the basic elements of defective or dangerous product, if it's a negligent products liability case, not a strict liability case, that it was negligently designed, negligently manufactured, or the defect was negligently caused because of a negligent error or omission on the part of the manufacturer, and that caused or contributed caused the damages in the person. And you got to get by all their defenses in order to be able to recover your damages in a case. Let me go to another question. We're going through a ton of questions here. This is great. I apologize if my computer's locking up a little bit. Here's a good question. What do I do if I've been hit in a car in a crosswalk? Call a lawyer. So if you're in a crosswalk, there's various laws about pedestrians and auto, and that if you're not in a crosswalk, it can be difficult to recover, because then the argument is you're supposed to yield the right of way to the vehicle. But if you're in a crosswalk, validly crossing with a light, or if you're not in a crosswalk, but if you're like in neighborhood streets where if one sidewalk goes here and one sidewalk goes here and you're crossing a street right between there, that is the crosswalk, and the pedestrians have a right of way at that location as well. There's a lot of nuances on pedestrian and vehicle cases. And I'm assuming this question is you're hit by a car in a crosswalk, which is the deal, right? Which is what always happens, because that's what injures people. If that's the case, then you have a claim against that driver, against that driver's automobile insurance policy. And often pedestrians who are hit in such circumstances are significantly injured, because the force of a 6,000-pound car, or whatever it is, force equals mass times velocity. That mass of that car is a lot more than the person. And people get severely injured when that happens. We've had many of these cases, and the injuries can be bad. And the poor clients, we really work hard with them and try to find additional insurance, try to fully compensate them for their injuries. Let me go to another question. Remember that, folks, if you have any questions about any other matters, you can always contact our firm at info@burgerlaw.com. We all get those emails. We like to answer those questions. Let me go to a question from Brennan. How does bad weather affect truck accident settlements? Can I sue? Can't sue weather, or can you? Well, no, you can't. However, sorry, I'm getting texts from my daughter Audrey right now. So, interestingly, Brennan, the commercial uniform, and I have it right over here, the commercial uniform driver's guide, the same driver's guide that we have for regular drivers, is one for commercial truck drivers, and that says, and the regulations say, and the training to truck drivers say, that the truck driver has to decrease his speed in inclement weather. So if you can't see enough ahead of you to stop in time, if someone suddenly stops, the truck driver has to slow down. You can't bring a 70,000-pound tractor trailer flying through fog, because people stop. And in highways and roads, people stop. And trucks can't brake as quickly as other cars, especially if they're holding heavy loads. So you can't sue the weather, but we all know you don't drive the same in the weather, and that's on the driver, not on the weather, right? So if you're driving home today and you can see outside, you can't see outside because my light's on. It's kind of gray. We're hitting this time of year when we have this gray, sometimes freezing. It's beautiful. It's warm out today, but this freezing ice and stuff. You can't drive as fast. You slow down in inclement weather. You slow down and slow. Snow is slippery. You drive slow. When you come to a bridge, you slow down. You see all those signs. So ice coats overpasses and bridges faster than it does regular roads, because those have the wind underneath. It cools them more, and they're not on ground, which ground is warmer than the air. Ground, like if you go down in a cave, it's like 55 degrees. So that's warm. So it's going to warm up the ground. It takes ground longer to freeze if ground freeze than it does a bridge. So in all those things, the driver has to be careful about. And accidents, when they happen like that, they have to be careful. There was just a kid who was sentenced to 110 years in prison for causing a terrible tractor trailer crash on Highway 70 in Colorado that I read the other day. Truck drivers have to be safe on roads, and that includes adjusting to the weather. They can't stick their nose. They can't put their head in the sand and ignore the weather that's affecting their driving. So I'm going to try to. Thanks, Jeff. Uh, uh, David asks, and Rodney's already answered the question. So David asks, what makes Burger Law a better law firm for managing car accident case than other firms in the area? Well, Rodney already asked it. Rodney's a great paralegal at our office, and he said, hey, I got this one awesome paralegal. But no, let me really answer that question. What makes Burger Law different and better for managing a car accident case than other firms in the area? Well, I think it's our personal and team approach to cases, and also knowing that you're not a cog in the wheel, you're not a number. It's the other side. If you hire our firm, the other side knows in this case that we're going to demand and make them give you full compensation for your injuries, and that if they don't, we're going to file a lawsuit, litigate the case, and try the case and get a great result. And we have that reputation. We do it with every case. We file a lot of lawsuits. Sometimes we file lawsuits because these insurance companies know that they're only going to offer X amount if you don't, and then we file a lawsuit and it goes to a different adjuster, a different lawyer gets the case. The other lawyer calls me up and we start working on a case, and they're going to tell the adjuster, listen, the Burger Law people, Gary and all this team, they're going to go try this case unless we offer them real money in this deal. So let's not stop jerking around. This isn't a firm that's never going to try a lawsuit. This isn't a firm that's never going to file a case. These guys walk the walk. They don't just talk the talk. So let's treat them with respect. Let's treat their clients with respect. Let's put enough money on the table to resolve the case to show that respect. And that's why I think we're better than a lot of other folks, because we do that. We're not too proud to go file a lawsuit and do the hard work and the hard case to make sure that our clients get real value for the case. We do it all the time. We do it every day. It's one of the things that I learned from my parents and my family. Don't be afraid of hard work. Don't just take the easy money. Don't just do this. Let's do the hard work and help people. And that's what we're here. That's our mission. We're here to help people. We're here to fight bullies. We don't want our clients to get pushed around by insurance companies or anybody else. And we're going to stand up and push for them to the end. And we do it every day. And we're proud to. It's our job. There's a lot of people, a lot of harder jobs than I have, believe me. So let me move on to another question. Eric asks, how do you calculate future lost wages or future medical costs? Great question. Here's how we do it. Let me take the latter is the first. So in future medical costs, when we are preparing the damage to the case, we'll look at the medical records, or we will take the depositions of the medical provider and say, what does this person need? This person's had an injection every 3 months for the past 2 years. What are they going to need? We're going to go depose the doctor, and they're going to say they're going to need this again every 3 months for at least 5 years. We calculate the price of that. We can add medical inflation. So medical inflation is always higher than the cost of goods inflation, the COLA, cost of living adjustment that we see. We have the news now is high inflation, but medical is going to be even higher than that. So we can do that. The other thing is that juries are empowered in most states and in Missouri and Illinois to calculate future value and also to reduce numbers to present value. It's hard to do, but I was an economist before law school or economic trained in college at good old Mizzou. And we can calculate that for the jury, and we can do that. So those are medical costs. You get the evidence from the medical providers. So if someone has a back surgery, most doctors are going to say they're going to need another surgery in 10 years, in 15 or 20 years. They're likely to need another surgery, another laminectomy, fusion, whatever it is. If someone has a hip replacement, those last 20 years, they're going to need another one. If someone has, so there are some medical conditions that that are pretty clear future medical costs and future medical needs, and we're able to calculate that. How do you calculate future wage loss damages? In those cases, we establish evidence from doctors that the person has physical limitations, that they can no longer do their job or no longer work at all. And then we can also hire a vocational rehabilitation specialist. There's people that do that. The Missouri Department of Vocational Rehabilitation, sometimes we send clients to for them to do a vocational assessment. So you can hire a vocational rehabilitation specialist, or voc rehab expert, as they're sometimes called, who will come in and say, this person can't work at all. We've looked at the physical restrictions. There's no way they can't work. Or if they can't, but some people they can work. Well, they can work, but they can only work so many hours a week. And I know the job market. I've done a labor market survey. I've looked at, you can't get a job if you can only work 3 hours a day. Or you can work you maybe only work 3 to 4 hours a day for only 3 or 4 days, but then you're going to be physically exhausted. You're going to miss 2 weeks of work. And not many employers are going to employ you. Or you made 200 grand a year before this accident. Now you have these limitations. So the only real jobs you're going to be able to get is a minimum wage type job, an $8 an hour job. And so you're going to have, you could go out and earn that money. And then we take the wage loss differential between what they used to make and what they can make now. We could also hire an economist, and we do that sometimes too, to calculate wage loss damages. So you can get the doctors to talk about the medical side of it. You get a voc rehab person to talk about the labor market and the impact of the labor market and what kind of jobs they can get. And then you couple all that with an economist who can do the actual calculation of wage loss damages, because those can be complicated. Because the wage loss damages go out in the future, you have to reduce in the present value, because it's also loss of benefits. So the person may have lost their job, but they also lost their health insurance, their retirement, and other stuff. That can have an impact. So sometimes hiring economists is also a good way to put those damages in a bow, or to really calculate it in that way. It's been 56 minutes. I'm going to get going, folks. Merry Christmas to everybody. If you get hurt in a job, can my employer terminate me if I file a work comp claim? It's against the law to do that. We hire retaliation for work comp claims. Those are employment claims. We handle those from time to time when that happens to our clients and our work comp claims. The employer can do it. They can fire you, but it is against the law. And we can also get the state of Missouri can come in and investigate those claims as well. Hey, this is my last Ask a Lawyer for the year. We're going to take a couple of weeks off. Everybody enjoy the holidays. Everybody, happy holidays. Merry Christmas. I hope everybody enjoys the end of the year and rings out 2021 in good fashion. Thanks, everybody, for watching and listening. Appreciate it.